Hello. In this presentation, I am going to cover the subject of the right to counsel. Basically, I'm going to explain what the right to counsel is, how it's beneficial, potential issues that can arise if you do not have counsel during a jury trial, and so on. I will also provide examples of an actual court case that I believe will assist in making it easier to understand the process. Found within the Sixth Amendment right of the Constitution is a citizen's right to counsel. This amendment means the defendant has a constitutional right to be represented by legal counsel during a defendant's trial. The Sixth Amendment to the United States Constitution furthermore states that the requirement for assistance for counsel and is for the accused in all criminal prosecutions. According to an article that I found online, under Hine Online, quoting, "Contrary to common belief, our legal system does not guarantee a lawyer to every person whose freedom is at stake." Many people believe that anyone who is going in front of a judge is automatically granted legal assistance or advice. However, the most common incidence of this scenario is where an offender finds him or herself standing alone to face a prosecutor and judge in the beginning stages of a criminal hearing. It is not widely considered that the offender requests any legal counsel until later stages in the process, which makes it much more difficult to continue at that point when it has gone so far without legal assistance. Another problem that can be faced is that they can find themselves in a position that cannot be reversed. So like I said, it goes so far, they haven't had any legal counsel, and they're not able to reverse a negative situation that maybe could have gone differently had they had counsel. So the case that I will use is Gideon versus Wainwright to give a description of the right to legal counsel. This is a landmark case in our country. That simply means the case is studied for its legal and historical purposes. In this case, in 1961, Gideon was put on trial for stealing a small amount of money from a local establishment. He represented himself in front of a jury during this trial. He was found guilty and sentenced to 5 years in a state prison. Gideon appealed his decision, stated that he was denied his right to legal counsel, which therefore he was saying violated his Sixth Amendment rights. His appeal was denied, and at the time, the right to legal counsel was in place, but only for federal courts, which he obviously was not in front of at the time. While serving time in the state prison, he wrote a letter to appeal the United States Supreme Court. He argued that his 14th Amendment rights had been violated in the sense that these rights applied to state courts should have provided him with a right to legal counsel in a state court where his trial was held. Gideon was awarded another trial through his appeal, and in his new trial, he was able to discredit the eyewitness testimony from original case. So his legal assistance was able to help him with that moving forward. As a result, he was acquitted of all charges relating to this criminal offense. Furthermore, the case led to the overturning of the right to legal counsel only being guaranteed to federal cases. Therefore, due to this Gideon versus Wainwright, the right to legal counsel was also given to state courts as well. Other charges were made to the system as well. Concerning Gideon versus Wainwright. An offender does not need to be able to financially support legal assistance for a trial. An attorney will be provided to him or her regardless of the financial situation. So if someone cannot afford legal assistance, they will still be offered an attorney. Research has been done on the subject surrounding the idea that all citizens should be granted the right to legal counsel. One study conducted in Baltimore City defended the liberty of nearly 4,000 low-income defendants accused of non-violent offenses. Over an 18-month period, they had to gain perspective of how legal representation affected court hearings for those who gained representation in the earliest stages of the criminal proceedings. Many instances where individuals were not given the right until later stages in the process were studied during this trial. This was put into place to see how differently things may have gone for an offender if legal counsel were offered at the beginning stages before bail was even set. According to this research, the study revealed that early representation enhances a defendant's respect for system overall confidence and fairness in assigned legal counsel. That was quoted Colbert, Harsteiner and Bushway, 2002. In addition, this study showed that more than 2.5 times as many represented defendants were released on their own recognizance from pretrial custody as opposed to unrepresented defendants. Additionally, 2.5 times as many representative defendants had their bails reduced to an affordable amount. Indeed, delaying representation until after pretrial release determination was the single most important reason for a lengthy pretrial incarceration of people charged with nonviolent crimes. This is really a shame in our country that that kind of thing goes on, because many people cannot afford to post bond. Studies continue to suggest that lengthy time periods in which offenders without counsel face deprivation of personal liberties is outlandish. They also suggest this type of instance violates our country's deeply rooted process to protect any individual who has been accused of a crime. Finally, it was found that denying counsel to an accused indigent during the crucial period following an arrest has disastrous consequences on the legal system's ability to render fair and just verdicts. Lawyers have indicated that these beginning stages are the most crucial time periods for offenders when it comes to how proceedings will go. According to the final findings from these studies, things are more likely to go well or positively for the offender if he or she was granted some sort of legal counsel before the very first court appearance. However, things are more likely to go in a negative direction for the offender if he or she begins their court proceedings without any legal counsel. Another area of trial for the Sixth Amendment right to have legal counsel is the area surrounding the death penalty. Cases which include offenders facing the death penalty are particularly difficult for attorneys to pick up once they have already began the proceedings. Death penalty cases are very difficult for an attorney to navigate their way through to begin with, so to come in the middle of something or once the proceedings have already begun is very difficult. An article by Casimir, 1990, stated that a godly number of the most talented and dedicated members of the private bar have collaterally attacked capital convictions or death offenses. It is extremely difficult for even the best lawyer entering the fray after direct review is complete, the point at which private death penalty lawyers typically do become involved, to pick up the pieces. These changes in our legal environment surrounding death penalty cases and representation have changed immensely over the years. Another landmark case was Strickland versus Washington that led to some of these changes. That case touches on the standards which are applied and determined whether or not a defendant did or did not receive the correct or effective amount of assistance that should be granted to them under the Sixth Amendment. In this particular case, Strickland argued to overturn the ruling of his death sentencing penalty. However, this was a very tricky thing to do. In order for this to occur, he would need to prove that the legal counsel which was appointed to him was incompetent. Sadly, research has proven that the legal assistance being provided to indigent offenders facing the death penalty is coming far too late, as stated above. So not only just in standard cases, but very difficult in death penalty cases if there's no legal counsel provided. Excuse me. These are some very interesting and accurate points that are being made on this end of the argument, as far as people arguing that the right to legal counsel should be given to anyone. So even in traffic violation, traffic court, or something like that. But they are saying that this requires a great deal too much. It's far less a standard for effective assistance of counsel than a standard for disposing of effective assistance claims. And finally, a death row inmate who claims that counsel's assistant at the guilt trial or penalty trial was so ineffective as to require reversal of his capital conviction sentence shouldn't have to clear two formidable hurdles. It's difficult enough to overcome the first hurdle, let alone establish that a lawyer's performance was deficient. Much research has been done surrounding the subject of having the right to counsel, legal counsel. and of the Sixth Amendment rights of the United States Constitution. However, I believe that far more can be done to fine-tune these rights, making them very effective to the last drop. Thank you for listening to my presentation. Bye.